लाइट जोन है
जी सर।
Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi. Different time I'm talking about the different types of legal matters, social matters, or legal matters, or the sociological matters. But right now I would like to discuss about the legal matters. This is much more important, rational, impactful, and consequential for the present days, as well as for the future days also. So, in today's discussion, I'll discuss about the plea bargaining and the effect of the plea bargaining in our common justice or the judicial mechanism. Before making generalized ideology or generalized discussion, I have to mention the definition of the plea bargaining. Plea bargaining is a legal concept which is originated from the European culture and the European society. But the people of Bangladesh they are not concerned about the plea bargaining and the plea bargaining effect. So, in the common definition, clear bargaining is that whether the convicted will be free from any kind of legal encumbrance in bargaining his legal thoughts and the legal jurisprudence. This is a very new culture in our common legal system and the legal culture. So, as a general discussion, Bangladesh is following the civil law system. That means the criminal law system is directly originated from the common legal system. And common legal system is based on the British culture, British situation, British entrepreneurship, or more even the British ideology. Even after 250 years ago, we did not get any kind of clarification ideology to make a very good justice system with a very short time. For these reasons, directly or indirectly, we are following the British legal common methodology or the British common legal system. But I believe that if the Plea bargaining concept is very famous in Bangladesh. That will much more effective for the Bangladeshi situation and that will reduce the burden of our case laws and the case procedures. For example, if a person would like to make a palpitation before the court, it takes too much time. And from the previous discussion, right now in Bangladesh, more than 45 lakhs suit has been filed, but it has no result. That means it did not get any kind of single result from the judgment or the judgmental issue. From this perspective, clear bargaining can be a very good choice in the ADR mechanism. You know that in the ADR mechanism, there is no types of single affiliation of the criminal judicial system or the criminal jurisprudence. But in the modern times, the legal philosophers they totally depend on the criminal legal dimension and the criminal legal jurisprudence. So, in the perspective in the criminal legal history, the European culture and the European society, they directly follow the clear bargaining mechanism. And clear bargaining mechanism is very famous in the European culture, but it is not also famous in the Bengali culture, in Indian culture, in Pakistan culture. That means in the Commonwealth country, the plea bargaining concept is not famous. But in that mechanism, the government can take some authentic ideology or the ideological practice to make it so much rational and impactful for the common development of our criminal legal system and the criminal legal jurisprudence. Before that, I would like to talk about the advantages of the plea bargaining. If the government is interpreting the plea bargaining concept in our criminal legal system, that will be much more effective and perfect for our common people because the common people has no money, the common people has no time. Within a very short time, they can get their justice through the criminal judicial system in Bangladesh and the culture of the Bangladeshi practice. The second reason is that plea bargaining definitely reduce the burden of case laws. Whenever the people will get the effective situation in the meritship of burden of criminal legal system, in the mechanism they will 100% depend on the plea bargaining effect and ideology. The third advantage is that in the European culture and the European society, plea bargaining is a very famous context. Even within a very short time, they actually make a very good justification over the case matters and the case schedules. So, if the Bangladeshi government would like to mention some of the basic interpretation of the judicial system, pre-judicial system, or the legal system, surely they have to follow the clear bargaining effect in our common legal system and the ideology. The fourth advantage is that in the criminal justice system, there are four kinds of clear bargaining effect. One is fact bargaining, one is sentence bargaining, one is partial bargaining, and another is actually factual bargaining. And with this guardianship, it actually depends on the ADR mechanism and the ADR process. So having lots of political problem and the social problem, I believe that if the government is actually depend on the plea bargaining effect, that will be much more radically effective for the social development in our common legal system. But apart from this, there are some of the legal disadvantages also. The basic disadvantage is that people has not a single education on the plea bargaining effect. Even 90% of our common legal people, they have no idea how they will evaluate their criminal legal meritocracy on the basement of the criminal legal system and the postponed related activities. The second reason is disadvantage is that whenever people are not more concerned about the plea bargaining effect, how you will make a very good justification over that effect. This is actually not possible or not desirable also. The third disadvantage is that we have no legal structure. For example, we have Legal Aid Act 2008, even in the civil matters, we have ADR mechanism in mediation, in arbitration, or arbitration in the appellate division. But there are no common legal structure for the plea bargaining effect in Bangladesh. So with a very short time, it's literally impossible to implement the plea bargaining effect in our legal structure or in our legal culture. So this is one kind of basic problem for establishing the plea bargaining effect. But in the previous time, sometimes the government as well as the judges also interpreted it and established some of the principles related to the plea bargaining effect. For example, you can mention the approver terminology. Approver terminology, it is not the direct plea bargaining, but sometimes it supports the plea bargaining effect. Even Section 133 of the Evidence Act in Bangladesh directly support the plea bargaining concept and the conceptualized ideology. On the other hand, Section on 4, subsection 2 of Evidence Act directly affiliate with the plea bargaining effect. Even Section 29 of Evidence Act directly affiliated with the plea bargaining effect. So I think that first of all we have to make a very good exposure of the plea bargaining for the senior advocate and the judges also. Whenever they will satisfied with this legal terminology, in that mechanism we can expose it for the common people, for the common ideology, and by this way we will definitely ensure a very good criminal legal mechanism in Bangladesh. But before that, I have to give some recommendation regarding the plea bargaining effect. So you know that it's actually an effect of the civil legal system, and we are following the common legal system. So if the Bangladeshi government would like to establish the clear bargaining effect in Bangladesh, first of all, they have to mention the mixed method of legal system. Otherwise, this is not possible in interpreting the criminal legal system on the basis of the clear bargaining. The second recommendation is that we need the public education. Whenever people will much more educate over that issue, in that mechanism, it is not a very big deal to establish or reschedule the criminal legal effect in our criminal legal systems. The third recommendation is that actually it will be based on the expert and the expert related activities. And 90% of our advocate and the judges, they have no ideology about the plea bargaining effect. So as far as it possible, we have to make a great education system regarding the plea bargaining effect, and by this way, in the future time, we will ensure a appropriate legal system that is based on the plea bargaining and the effect of the plea bargaining in the future time. Thank you. Salaam.